On Friday, June 23rd, the Supreme Court ruled that Texas and Louisiana do not have standing to sue the Biden administration over an immigration deportation policy, delivering a win for the Biden administration in an 8-1 ruling. Now, for those who don't know what standing means, besides standing on your feet, standing means that you have skin in the game. That when you say you have skin in the game, meaning that you're going to be affected by whatever may happen. And though the court cautioned, that doesn't mean the White House couldn't be sued in future cases by states. In this particular case, they couldn't. So in U.S. versus Texas, it concerned Texas's and Louisiana's legal challenge against the Biden immigration policy outlined in September 2021 that prioritized some undocumented immigrants for deportation over others. And what did they prioritize? The Biden administration said, we're only going to deport people who are criminals or terrorists. That's it. You're not a criminal. You're not a terrorist. We're going to leave you alone. And Texas and Louisiana said, that's crazy. We want to deport everybody. And Biden says, well, we don't have the resources to deport everybody. So who we're going to deport is criminals and terrorists. That's it. And the Supreme Court ruled Texas and Louisiana, as I said, did not have standing to challenge that policy. And they reinstated that Biden administration policy that from now on, at least throughout the rest of the Biden administration, I mean, maybe you'll trip over immigration somewhere. They're only going to deport people they find at the border. They're only going to deport people within the United States of America that have a criminal record or are suspected terrorists. Justice Brett Kavanaugh wrote in the court's opinion that the Supreme Court ruling doesn't mean that federal courts may never entertain cases involving the executive branch's alleged failure to make more arrests or bring more prosecutions, noting that there are other situations in which it is possible that the states would have standing, and there might be more of a case challenging policies around detaining undocumented immigrants who have been arrested rather than arresting and prosecuting them in the first place. The Biden administration directive at the heart of the case argues that someone not being a documented immigrant should not alone be the basis for an enforcement action against them, meaning be put in deportation, arguing that the majority of undocumented non-citizens who could be subject to removal have been contributing members of our communities for years. So what does that mean? It means that unless you are a criminal, unless you are caught at the border, or unless you are a suspected terrorist, you should be okay. What does that mean for Florida? The same thing. Governor Ron DeSantis can't do jack you know what to you. He is only a governor. Only President Biden, the executive branch, can decide who to deport. So Florida can report all the people they want to immigration. And based on this policy in the Biden administration, unless you're a criminal, unless you're a terrorist, you should be okay, or caught at the border, you should be okay. So the memo for enforcement will go into effect immediately, and this is exactly what the memo says. It states the Biden administration will prioritize for deportation undocumented immigrants who pose threats to national security by being suspected of terrorism or espionage, have a history of criminal conduct that makes them a threat to public safety, or poses a threat to border security if they were apprehended at the border or port of entry. Drop mic. All the governors in any state can report you till the cows come home. But if immigration's not going to enforce deportation against you, you have nothing to worry about. Everyone in Florida breathe clearly now. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.